In the late 1970s and early 1980s, the world saw the emergence of a phenomenon that has delighted some and infuriated others, especially in the South. The rise of the televangelist, preachers on radio and television promising listeners the good life promised by God in exchange for the faith to donate $11.99 a month to the ministry. Jim Bakker is among the most famous. He and his wife Tammy Faye were the outrageous proponents of the prosperity gospel that if you donate to the church, God would reward that faith with material blessings. Bakker was convicted of fraud and conspiracy to commit fraud for, among other things, using church funds to pay hush money to his secretary to cover up an affair. As financial and legal problems swallowed up his ministry, Bakker also came under scrutiny for his lavish lifestyle, including his air-conditioned doghouses for his pets and the gold-plated bathroom fixtures in his lakeside home that would have made Elvis blush. Bakker lacked integrity. He said one thing while having entirely opposite values and principles. And Bakker's lack of integrity did not just hurt himself or his church members. It hurt the credibility of Christian ministry, period. Hello, and welcome to the lecture series for Ethics in the Legal Environment at the University of Mississippi. This is the final unit in the course, so consider this a sort of capstone in which we will cover topics related to the integrity and reputation of the legal profession. As with Jim Bakker, lawyers are responsible to the profession for maintaining its credibility and the faith and trust people have in lawyers. In this first of 3 lectures on the integrity of the profession, I'd like to discuss 2 topics. First, the duty of honesty to admissions or review boards, and second, the respect that should be shown for officers of the court. But first, what does it mean to maintain the integrity of the profession? On one level, it means that how lawyers behave outside the office and courtroom is the business of the bar and the profession. Attorneys do not necessarily clock out when they leave the office as others do, and their behavior and past behaviors reflect upon the legal profession. For this reason, both the Board of Bar Admissions, to which a lawyer applies for admission to the profession of law practice, and the ethics review boards will evaluate the character and fitness of candidates for law practice. Why? Well, trust and confidence are absolutely foundational aspects of the law practice. Lawyers' duties of confidence and loyalty assume those character traits. Trust is not an on or off characteristic. So candidates for admission to the bar have a duty of truthfulness in all representations to the Board of Bar Admissions. When applying for admission to the bar, you will be asked questions about your personal, professional, and criminal history, and you will have a duty to reply truthfully. That duty extends to you after you are admitted to the bar and face an inquiry, possibly if ever an ethics complaint is filed against you. This obligation for truthfulness is trifold, meaning you can make 1. No false statements of material fact in either proceeding. 2. You have a proactive duty to correct the record of the board if the board is mistaken about a material fact. And 3. You have a duty to comply with requests for information from bar admissions or disciplinary boards. On some professional applications, you may feel that aspects about your history are private and off limits. Maybe it is unfair to ask questions about your criminal history on your application for grad schools, but lawyers are held to a higher standard in order to instill trust in the profession from the public and from clients. So it is required of attorneys to be fully transparent to ethical review boards. There are some limits to this duty of honesty. For example, the duty of confidentiality to the client trumps the duty of honesty to the review board. Here's a hypothetical. An ethical review board requests information about an attorney's conduct that might also implicate his client in illegal or unethical conduct. In such a situation, the attorney would not be permitted to break his client's confidences. However, there are other normal protections that do not extend to cover the attorney's duties of honesty to an ethics tribunal or admissions review board. For example, in one case, a court was not persuaded that the First Amendment protected a lawyer who was a candidate for judge in Minnesota. The candidate had issued a campaign statement accusing his opponent of some misconduct. An ethical review board requested the candidate to disclose the identities of the sources of the information for those allegations, and the candidate declined, claiming First Amendment protections. The Ethics Review Board brought charges against the candidate for making statements that had a reckless disregard for the truth and for violating his duty of honesty, and the Minnesota Supreme Court found that the review committee's request was rationally related to the charges of professional misconduct, and that the information, the identities of the supposed people who made these allegations, was not protected by the First Amendment. Note here that the unethical behavior of the lawyer in question was not even related to a client or to a court case. He acted unethically as a candidate for office. Essentially, the lawyer was acting in a personal and political capacity, not as a lawyer. But his conduct outside the office and outside the courtroom was still sanctioned by the bar. This is the key takeaway from this lecture. A lawyer's conduct outside the strict confines of his job description may also be the subject of bar discipline. A lawyer, for example, with several convictions of DUI, public intoxication, or misdemeanor drug possession, may be referred to the ethics committee even if his substance abuse has not yet caused harm to a client. Substance abuse calls into question a lawyer's duty of competence, so the bar may investigate that. Let's turn from character and fitness to respect for officers of the court. Attorneys' conduct toward judges and other officers in the legal system should be respectful. This shows up frequently in the manner in which lawyers talk about judges and officers in the legal system. Contrast these two statements a lawyer might make about a ruling that didn't go his way. Here's the first one. We're disappointed in the result because we feel that the testimony which the judge excluded was relevant to the case and the jury needed to hear it. Now here's the second one. It's clear that the judge in the case is in the bag for the defendant, and frankly, I'll be surprised if he doesn't get removed from the bench for corruption. While that first statement expresses an opinion about the ruling, the second goes further and suggests, without evidentiary basis, misconduct and bad faith on the part of the judge. This kind of reckless talk about the justice system does a disservice to everyone, including the public, because it erodes confidence in the legal system. For an example of discipline against an attorney for such kind of speech, let's compare and contrast the outcome of two cases. In re disciplinary action against Graham, a Minnesota case from 1990, and in the matter of Green, a Colorado opinion from 2000. In Graham, a Minnesota defense attorney representing a father who was accused of child abuse overheard some speculative talk during an informal conversation at a bar that the prosecutor in the abuse case had used his political connections to improperly persuade the judge to find against Graham's client. In a subsequent letter to the United States Attorney, Graham alleged just such misconduct, saying that, quote, it was in fact known to Mr. Rathke, Mr. Milligan, Judge McNulty, and others how the case would be decided some 3 weeks before the opening of the trial, all as a consequence of corrupt influence, end quote. An attorney misconduct tribunal determined that Graham said those things with reckless disregard for the truth in violation of, among others, Rule 8.4d that prohibits conduct that is prejudicial to the administration of justice. The Minnesota Supreme Court agreed and found that Graham never accepted responsibility for his actions or even acknowledged his own violation of the rules. He was suspended for 60 days. However, in Green, an attorney similarly criticized a judge, but ultimately faced no sanction. In that case, attorney Julian Green authored several letters and motions to the judge in a trial containing relentless criticism and contempt for the judge. Specifically, Green vehemently objected to the judge's use of the word competent to describe Green's skills in an order awarding Green attorney's fees in the case. Green felt that the fee award was too low and was moving for an increase, while also moving for the judge to recuse himself because Green thought that the judge's language describing his skill as merely competent was an indicator of racism. Green is an African American. In a third letter on the subject, Green wrote the judge, quote, "I do not believe I can state my case more emphatically than I already have. I want you off this case. I am entitled to, and I affirm my right not to have my attorney's fees determined by a racist judge." End quote. In considering whether to impose a sanction on Green for this accusation, or even if the accusation was a violation of the rules, the Colorado Supreme Court compared such criticism of judges to the definition of malice in New York Times versus Sullivan. They found that attorneys who criticize judges are only subject to discipline and sanctions if the statement is false and if it was uttered with reckless disregard for the truth. The Colorado court noted that Green's conclusions about the judge being racist were Green's opinion, and that all of the facts upon which he based that opinion were reliable facts. So, what is the difference between the Graham case and the Green case? Well, in the first case, Graham, the disciplined attorney made a factual statement that was defamatory and untrue. Graham alleged that the judge had made a decision about the trial 3 weeks before the trial, and that allegation was based merely on casual secondhand conversation heard at a bar. That's a factual allegation that can be proven false or true. In Green, however, the attorney offered his opinion that the judge in the case had racial biases. That is pointedly not a fact which can either be proven or disproven. The distinction between provable fact and unprovable opinion is the distinction in these cases. In both words and in deeds, in and out of court, attorneys have to act in a manner that reflects well on the profession. Duties of honesty and competence can be negatively implicated by out-of-court conduct. In the next lecture, we will discuss the obligation of all attorneys to report misconduct if other attorneys, when and if they learn about the misconduct of other attorneys. Until next time.